Today, I want to talk about a silly little bill that's making its way through the California legislature, and potentially it can affect your ability to take possession of a new firearm. Now, before we get into this, I want to mention a special contest that the USCCA is doing right now. It's going to be ending soon, and you can click on the link directly below my video and you can see all the details of it. I'll give you a hint. Most likely it can fit in your holster. All right, so let's talk about this AB 574. So this is a bill that has been sponsored by Assemblyman Reggie Jones Sawyer. And at first blush, it might appear to be somewhat innocuous, right? But it has some really negative implications associated with it. Essentially, it demands, in fact, I'll read you directly from the Legislative Council's Digest from the state of California. This bill would additionally require that the register or record to include the acknowledgment by the purchaser or transferee that they have within the past 30 days confirmed possession of every firearm that they own or possess. All right, so what does this mean? Well, when you go to a gun store and you are in the process of engaging in either a dealer record of sale or you're getting going through a private party transfer, utilizing the FFL in order to facilitate that, you have to fill out a 4473 form. This is the federal document. While you are doing that, simultaneously, the store clerk is in the process of filling out an electronic version called the dealer record of sale, or the DROS. This is the information that then gets transmitted to the state of California that initiates the background check. Now, during the DROS process, there are 4 questions that the dealer is supposed to ask the transferee. And you have to click yes or no on the website for each one of these questions. You know, whether or not you're a prohibited person, whether or not you're a felon, whether or not you've been adjudicated as a mental defective, things like that. This would add one more. Essentially a query. Have you or will you affirmatively state that within the last 30 days you have confirmed possession of each of the firearms that you currently own? Now, if you were to say no, that ends the process. The system will not allow you to progress. You must, according to this new potential law, you must go through and do an inventory of all of your weapons prior to going through the DROS. If you answer yes, all right, yeah, of course I have, okay? You take it flippantly, you actually haven't done it, and it was subsequently determined that a firearm was stolen, you would be found or potentially charged with the act of committing perjury. So there's some legitimate teeth to this. Now, at first blush, some of people are watching this video are thinking, well, this isn't like a massive intrusion on my rights. Well, it actually is. On a very practical level, it creates what can probably best be described as a major irritant. You know, let's say that you have someone who owns a home in Newport Beach. They have a second home, a mountain cabin in Mount Shasta, a few hundred miles away. And in that mountain cabin, they keep a hunting rifle. Well, theoretically, if they were to be a pathologically law-abiding citizen, before going in to do a DROS, they would have to travel to Mount Shasta to verify that that hunting rifle is still there, that it hasn't been stolen. So this creates that, you know, sort of like logistical issue associated with it. It also, interestingly enough, sort of violates existing state law. You know, under existing California state law, if a weapon is stolen, you have to report that weapon within a prescribed amount of time. But that time frame doesn't begin to accrue until you have actual knowledge that the weapon has in fact been stolen. And they understand this, right? It is entirely conceivable that somebody may have a weapon at a secondary premise that they haven't visited for 3 or 4 months, right? And 3 or 4 months ago, right after they left, there was a break-in, the weapon was stolen, and they simply haven't been made aware of it yet. So this would sort of force that clock by making you visit all of your other locations to go through this inventory requirement. What's also interesting, this law is so poorly drafted, it doesn't necessarily limit to guns that actually live within California. I mean, let's say for the sake of argument, you have a secondary residence outside of California. You have it in Idaho, right? And a firearm is stolen from your residence in Idaho. Theoretically, it could be interpreted that there's now a nexus to California law, right? Now, all of this being said, I have no doubt that it will in fact be voted by the legislature into law, and I have definitely no doubt that the governor of California is going to sign it into law. I have a high level of doubt that it will actually go into effect. As soon as this law is signed by the governor of California, it will be brought forth before a judge through litigation. And I suspect that the judge will issue a preliminary injunction against this law. As it's drafted right now, there may be a nexus to Second Amendment jurisprudence. We talked about the Bruin analysis before in past videos. I don't know that they necessarily need to get to a Second Amendment analysis. I think this thing fails on a Fifth Amendment analysis based on the forced self-incrimination. So, like I said, I don't think that this law will ultimately see the light of day. But for those of you who are, watching this video that live outside of the state of California, that are thinking to yourselves, why am I even watching this thing? Why is this guy bloviating about California, gun laws? It's, it's not going to affect me. Things that happen in California are kind of like a pathogen. They have the way of potentially infecting the union as a whole. And we've seen this multiple times, right? California gun laws have completely destroyed the Second Amendment community in Washington and Oregon. We can see some demographic changes that are taking place in Arizona. So this stuff does have a way of crossing state lines. We have to be eternally vigilant about these things. More to the point, it also kind of lets us know what the anti-gun community is seeking to really do. Right after Bruin, there have been these, attempts by state legislatures to effectively just create laws that clearly are going to be unconstitutional under any level of a Bruin analysis. Well, now we're starting to see a little bit of a more nuanced approach where they're looking at creating legislation that may not necessarily create a Second Amendment nexus. They are doing so in a way to make it more difficult for somebody to be able to exercise their Second Amendment rights, or potentially criminalize us for doing so in the first place. So like I said, eternal vigilance is absolutely mandatory. We'll see what ultimately happens with AB 574. Like I said, I suspect it probably will end up getting passed, but the jury's theoretically, I suppose, still out on that. In any event, please train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.